Recently I made a video about unqualified legal advisors, and it was a decision that was issued in the High Court by Mr. Justice Toomey in March 2025. Now, this is still March 2025, so it was a very recent decision. It involved lay litigants, Teresa Barrington and Sean Harrington, and they sued the Attorney General and Tailtea Éireann, that's Land Registry, and Promontoria Oyster DAC, and David O'Connor, and BDO, and MRCS Limited, and Paul Garavan. The interesting part about this case, and what initially got my attention, was the comments made by Mr. Justice Toomey, and he referred to comments made by other judges previously about unqualified legal advisors. And basically, Mr. Justice Toomey was describing unqualified legal advisors as malevolent actors, and also in his decision made the point that lay litigants are actually better off being unrepresented than having these so-called legal advisors, these unqualified legal advisors advising them. He also makes the point that it's a criminal offence to do that, for a person to give legal advice in circumstances where they're not actually a qualified solicitor or barrister and are not qualified to give legal advice. It's actually a criminal offence. But in the course of going through the decision, it was a 34-page decision, it's worth to read, and I've made a video about it, and I've made a video about the thrust of Mr. Justice Toomey's comments about malevolent actors and unqualified legal advisors and so on. But he made a very interesting point about something else that I felt was worth a video, and that is the question of justice and the right decision. In the course of the decision, Mr. Justice Toomey's decision, he points out and makes the point that the Barringtons had appealed one High Court judge's decision to another High Court judge, and leaving aside the probity and the correctness of that from a procedural point of view, the judge is making the point, or the Barringtons rather, were looking for justice. They were looking for a just decision. They were looking for the right decision. But Toomey in this case makes the point that there is no right decision. There is no just decision. What there is a decision by a judge on any given day, given the circumstances or facts of the case. And he makes the point that a different judge, given the same circumstances and given the same facts, could come to a different decision. And I think that's an interesting idea, it's an interesting concept, that there is no justice per se, there is no right decision per se, that there is simply a decision of a judge on a given day, and as I've said, a different judge could come to a different decision based on the same facts. And I want to just touch on that here and look at precisely what Toomey actually says in this decision. So the interesting point that I'm making, or the interesting point that Toomey was making here, starts at paragraph number 47, and this is specifically on this question of the right decision or a just decision. At paragraph 47, he says, the sense of injustice felt by the Barringtons that led to this application to set aside. He says, in considering whether these rare circumstances might exist in this case, it is important to note that the Barringtons come across as a genuine and hard-working couple. And Mrs. Harrington delivered an eloquent and passionate submission to the court about her views on the Constitution and the protection that she felt it gave her and her husband. For this reason, it was clear to this court that the Barringtons felt a deep sense of injustice and appeared to believe that they are entitled to have the order of one High Court judge set aside by another High Court judge because they did not obtain the right or a just decision. So he goes on then to, the judge recognises the sense of injustice the Barringtons feel, but he points out that it's important to point out that most litigants who go to court seeking justice but who do not get the result they want, whether about their property, their marriage, their livelihoods, their reputations, their children, etc., will feel that they've suffered an injustice, sometimes a deep injustice. However, he goes on then to ask the question, a litigant is not entitled to the right decision. He says the reason that the Barringtons have obtained justice, despite not getting what they believe was the right or a just result, is because, while superficially it may seem surprising to say it, litigants are not in fact entitled to the right or a just decision from a court. This is for the simple reason that there's no such thing as one right or just decision, or one just decision. This is because different judges will reach different decisions on the very same facts. And this point was made, or was put succinctly, by the Chief Justice of Northern Ireland, Keegan LCJ, when she stated that, quote, "There's a discipline to providing judgments. Colleagues might disagree with you. Other courts might disagree with you. That doesn't mean you're wrong necessarily. It means that there are different views." This statement, according to Toomey, highlights an important point, namely that just because one judge makes a different decision from another judge does not make one decision right and the other decision wrong. They are just different decisions from different judges. By highlighting the fact that different judges reach different decisions, Keegan LCJ's statement serves to highlight that litigants are entitled to a decision, not a right or a just decision. This decision should be reasoned and given to them by an independent judge after a reasonable time and after a fair hearing. If litigants receive this, then justice has been administered and they have got the justice they have sought. This is so even if they feel a sense of injustice because they did not get what they believe was the right or a just decision. The fact that different judges reach different decisions, while it might superficially appear to be a negative, is in fact a positive aspect of the administration of justice in Ireland. This is because Article 35(2) of the Constitution, all judges are required to be, quote, independent in the exercise of their judicial functions. And it's a clear sign that there is an independent judiciary if judges reach different decisions. This is evidence of the fact that judges are not subject to groupthink, but rather to make up their own minds independently. That is, independent not only of the legislature and the executive, but also of other judges. The fact that there's no such thing as one objectively right or just decision is vividly illustrated by the case of Minister for Justice and Equality versus Shuka. This is a 2021 decision. In that particular case, the applicant won his case, even though a majority, 5 out of the 9 of the judges who heard his case found against him. That is, 1 in the High Court, 3 in the Court of Appeal and 1 in the Supreme Court. They all held against him. However, since 4 out of the 5 judges in the Supreme Court found in favour of the applicant, he won. This case therefore starkly highlights not only that different judges reach different decisions, but more importantly that there is no such thing as one objectively right or one objectively just decision to which a litigant is entitled. And in this case then he goes on to say that the Barringtons, the lay litigants in this case, got a reasoned decision from Nolan J on the day of the hearing. In other words, that was the first High Court hearing. If Nolan J had failed to give any decision, the Barringtons would have cause for complaint, as would Mr. Garvin, as he would have been subject to the interim injunction until Nolan J gave his decision. The fact that the Barringtons believed that they did not get the right or a just decision and so did not get justice is not a basis for that decision to be set aside. So that's an interesting point. I think it's one I didn't really think about before. I always thought that there was a right decision and a wrong decision, but according to Toomey here, and he makes the point well, that different judges will make different decisions based on the same facts, and that's just the reality of it. So a person, when they go to court, do get justice when a judge makes a decision, and there's no objectively correct or right or just decision. There's just the decision of the judge on that particular day, and a different judge could make a different decision based on the same facts. Hope you find this video useful. If you do, I'd appreciate if you hit the thumbs up button down below, and I'll put a link to that case underneath the video on my YouTube channel. And this case is the Barrington case. They're lay litigants. I've also made a video about this particular decision of Toomey's because he goes to town, quite frankly, and gives an excoriating judgment or opinion about unqualified legal advisors giving out pseudo-legal advice. And he makes the point in his very, very first paragraph that if you went to hospital and there was quack doctors knocking around, you couldn't be expected, or you'd be absolutely mad to listen to or have unnecessary surgery carried out on medical advice of quack doctors, causing other patients to have their surgery delayed, etc., etc. And he makes the comparison between pseudoscience and pseudo-medicine and the quack doctors and unqualified legal advisors. Anyway, hope you liked the video. Thanks a lot.